Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos we are talking about family-based immigration. There is a subsection of immigration, family-based immigration, dealing with armed forces personnel. Now, let's say unfortunately your spouse or parent died in the armed forces as a result of combat. In this particular case, the immigration does permit a self-petition by a spouse, parent, or child of a USC, which is U.S. citizen, who served honorably in the armed forces. So in this case, it's whether your spouse, parent, or child, any one of those served honorably in the armed forces and died, then you can self-petition as long as the petition is filed within 2 years of the U.S. citizen's death. Now, as far as for a spouse, you cannot have been legally separated at the time of the death, and you cannot remarry during the petition process. Again, this is just if the spouse is the one who died. And then a child can apply even if he turns 21 and marries, or 21 or marries after the U.S. citizen's death. Now, a parent of a deceased United States citizen's armed service personnel may file an immediate relative petition even if the deceased USC child was under 21 years of age. Public charge, which is, if the beneficiary doesn't make if the petitioner doesn't make sufficient money, normally the beneficiary will not come in. That is waived for this type of petition, and this petition would be made on what's called the I-360 and the I-485, which is the adjustment application. Those can be filed concurrently. Okay, more on the coming videos.